Right. Miss Hannett? Oh, you're over there.
COVID groups.
Is the microphone on?
It has a green light showing.
All right, there we go. Yes, now it's better.
Better?
Okay, yep, thank you.
I'll start again. I appear on behalf of the 4 long COVID groups: long COVID kids, long COVID SOS, long COVID physio and long COVID support. I'm assisted by Ms Iyengar and Ms Siva Kumaran, and I'm instructed by Jane Ryan of Matt Murphy Solicitors. The inquiry has our written submissions. I propose to focus on key issues for our clients. That focus is not intended to diminish the importance of the remaining points raised in our written submissions, but the inquiry has them and will no doubt consider them with care. With that in mind, I propose to make brief submissions on 5 broad topics. The first, the scope of Module 3. Second, the Rule 9 process to date. Third, disclosure. Fourth, the length of the hearing. And fifth, the timetable for the inquiry's recommendations. The first topic, my lady, is a request for clarification as to the scope of Module 3 in 3 respects. These points are set out in paragraphs 5 to 16 of our written submissions, but in summary are as follows. The first point of scope is that the long COVID groups seek a clarificatory ruling as to where the impact of vaccines on long COVID will be investigated, and whether that is to be in Module 3 or in Module 4. There's evidence that vaccines both reduce the severity of existing long COVID and reduce, albeit not wholly prevent, new cases of long COVID developing. These are matters that must be explored by the inquiry, not least because people continue to suffer from long COVID and its effects. My clients made submissions at the last preliminary hearing asking for confirmation that these issues would be considered in Module 3, given the inquiry's decision to refuse the core participant status in Module 4, and that the reasons for that refusal included the point that the characterisation and identification of post-COVID condition, including long COVID, and its diagnosis and treatment falls within Module 3. The long COVID groups note the distinction drawn in the second preliminary hearing ruling between the development of therapeutics up to the point of use, a matter for Module 4, and the use of therapeutics, a matter for Module 3, but respectfully ask that it be put beyond doubt in your ruling on preliminary hearing 3 that Module 3 will include an examination of the impact of vaccinations on long COVID. That's the first point of scope, my lady. The second point of scope is a request for confirmation that the inquiry will consider the economic impact of long COVID on healthcare workers, in particular on their ability to continue working and the consequential financial impacts, and further, that the inquiry will investigate the impact on healthcare workers of the decision not to designate long COVID as an occupational disease. My lady, you ruled at the last preliminary hearing that issues relating to the designation of COVID-19 as a disability and the creation of a compensation scheme were out of scope. But these are 2 separate points, my lady. As to the economic impacts, the long COVID groups maintain that a proper focus on the physical health and well-being of healthcare staff, as required by issue 7A, necessarily includes an examination of the wider economic impacts for healthcare workers who contracted COVID-19 and who developed long COVID. Similarly, that long COVID was not recognised as an occupational disease has implications for issue 8D, namely reader reporting requirements for healthcare workers. The reader regulations prescribe the occupational diseases which must be reported. Long COVID is not one of them. There is evidence as to the underreporting of workplace COVID-19 via reader already before the inquiry, both from the Scottish TUC and the Health and Safety Executive. And indeed, the Health and Safety Executive witness statement notes that as of the 31st of October 2023, only 36 reader reports for long COVID had been received. In the absence of a designation of long COVID as an occupational disease, trusts are left with a discretion as to whether to report or not. And we say it's artificial to look at reader reporting, but not to look at the decision-making around whether or not long COVID should be designated as an occupational disease. And we say this is key to making proper recommendations as to the prevention of the spread of COVID and an understanding of how best to manage workplace safety. For these reasons, we ask that the inquiry make clear that both of these points, economic impact and long COVID as an occupational disease, are in the scope of Module 3. The final point of scope concerns the manner in which the inquiry will investigate the barriers to patients, both adults and children, accessing long COVID services and clinics, and the variation in the quality of those services. The long COVID groups will in due course invite the inquiry to make findings as to the adequacy of those services and recommendations as to how they could be improved. And we ask now for clarification as to how evidence to address these issues will be obtained. One possibility, as we suggest in our written submissions, would be to apply an equivalent approach to long COVID clinics as that being applied to spotlight hospitals. We note the submissions of Counsel to the Inquiry this morning about the lack of need or lack of perceived need to expand the spotlight hospital approach to other services, given the totality of the evidence. But we say that equivalent evidence does not appear presently to be before the inquiry in respect of long COVID services, and we ask the inquiry to give that some further consideration. In summary, on the first topic of scope, the long COVID groups say that all 3 points are fundamental to a proper investigation of long COVID in the healthcare system. They ask first the inquiry to confirm that they will be dealt with in Module 3, and if not, for the inquiry to confirm in which module they will be addressed. And that's the first topic. The second topic concerns the Rule 9 process, and we address this in paragraphs 18 to 21 of our written submissions. Two key points arise, which I wish to address you in oral submissions. First, the long COVID groups understand that necessarily the inquiry will focus on the healthcare response at a relatively high level, but the detail does, in our submission, remain important. And we regret to note that the witness statements disclosed to date that address long COVID provide evidence at such a high level of generality that no meaningful conclusions can be drawn from them. So, for example, it appears that none of the Rule 9 recipients have been asked to specifically comment on long COVID in children. As a result, none of the witness statements disclosed to date make reference to this, even the statement from the Royal College of General Practitioners and the statement from Public Health Scotland. And we also note this morning that Counsel to the Inquiry confirmed that the expert report on pre-hospital care will not comment on children's access to health care. For the avoidance of doubt, we don't accept that those kinds of gaps can properly be plugged by the use of the Rule 10 process. There's limited time for the hearings, which will inevitably limit the number and scope of the Rule 10 questions that can be asked. Further, these aren't points of clarification. They rather reflect a broader need for evidence to be sufficiently detailed in the first place. And indeed, we note, Counsel to the Inquiry, as we were reminded this morning, that pre-Rule 10 questions need to be proportionate and focused. The long COVID groups do wish to assist the inquiry in this respect, and to this end we will continue the correspondence that's been started directly with the inquiry's legal team, with suggestions of where further detail is required. The second key point, my lady, on the Rule 9 process concerns Rule 9 statements for the spotlight hospitals. We join cause with many of the other core participants to note that these must go further than just the Chief Medical Officer or equivalent. In particular, my clients invite the inquiry to seek evidence from a range of frontline healthcare workers, including those privately contracted by the NHS in the spotlight hospitals. My clients welcome Counsel to the Inquiry's clarification this morning that the evidence sought from spotlight hospitals includes the number of workers suffering from long COVID and the varying methods of support offered by hospitals. And further, we welcome the clarification that the issues raised include problems with the physical condition of the estate, infection protection and control guidelines, narrow corridors and poor ventilation. We note Counsel to the Inquiry's assurance that they're satisfied that the evidence obtained is not rose-tinted, but we are concerned that there's a real risk that this approach may lead to not providing a balanced evidential picture of the issues that affected healthcare workers. The inquiry will only have one side of the picture, and it's unclear how that evidence will be tested. So we therefore repeat our request for the inquiry to expand their request of the spotlight hospitals beyond one individual statement, and to seek evidence from a variety of sources, such as patient groups, professional bodies and trade unions, so that core participants may be satisfied that the inquiry is receiving a balanced picture. Further, in this respect, we endorse the submissions made this morning by Mr. Weatherby that the evidence sought from spotlight hospitals should include preparedness, questions around applicable national planning, infection protection and control, testing, staffing, and support for healthcare workers are of central concern. As we outline in our written submissions, the long COVID group's experience is that of a healthcare system unprepared to protect healthcare staff from developing long COVID and unprepared to manage and support healthcare staff who suffered from long COVID. My lady, the third topic concerns disclosure. We have dealt with this in paragraphs 22 to 23 of our written submissions. We welcome the significant amount of disclosure that the inquiry has provided to date, but again we join cause with the other core participants in noting that it remains imperative that the remainder of the witness statements are provided with sufficient time to allow the long COVID groups and the other core participants sufficient time to prepare properly for the Module 3 hearing. To this end, we invite the inquiry to do two things. First, to ensure that all or most of the disclosure is received by the end of June 2024 at the latest, and we welcome the comments of Counsel to the Inquiry this morning to that end. But second, to provide a timetable or roadmap now, indicating when particular witness statements and underlying material are likely to be provided, to enable both my clients and other core participants to properly prepare and marshal their resources. My lady, the fourth topic concerns the length of the hearing. We address this in paragraph 24 of our written submissions. Again, like other core participants, we are concerned about the adequacy of the 40-day allocation for the Module 3 hearing. And in particular, the long COVID groups note the importance of there being a sufficient exploration of long COVID, not least because people continue to contract long COVID and suffer its avoidable impacts. And we say that the current timetable gives rise to a real risk of there being insufficient time to ensure long COVID receives the focus it requires. And we respectfully ask the inquiry to keep the timetable under review and to monitor, in the light of the evidence that's received, whether it remains satisfied that long COVID issues, amongst others, can be fairly and thoroughly undertaken within Module 3 in the scheduled time period. If long COVID cannot be dealt with fully in the current Module 3 timetable, including the matters of scope that I began these submissions with, the inquiry is asked to consider whether long COVID should be dealt with in a separate freestanding module, as suggested by the Royal College of Nursing. Lady, my fifth and final topic concerns the inquiry's recommendations. My clients welcome your recommendations for the monitoring process, including that the institutions responsible for implementing the recommendations should respond within 6 months. The recommendations are urgent and have immediate and ongoing relevance, given that people continue to contract long COVID. In conclusion, the long COVID groups look forward to assisting the inquiry in the Module 3 hearing, but unless I can assist you further, my lady, those are the submissions on behalf of the long COVID groups.
Thank you very much for your help. Right, who's next? Sen Gupta. There you are. Another one hiding at the back.
I am, my lady. I appear on behalf of the Frontline Migrant Health Workers Group, together with my learned friend Piers Marquis. We are instructed by the Public Interest Law Centre. The group is comprised of United Voices of the World, Independent Workers Union of Great Britain, and Canlungan Filipino Consortium. We take this opportunity to highlight briefly some of the points made in our written submissions. We've divided up our oral submissions into those on the substance of the evidence your ladyship ought to hear as part of Module 3, and those on process and procedure in respect of the public hearings listed to begin in September, and timely preparation for those hearings. In relation to substance, I address our proposals in relation to, first, the scope of the expert evidence, second, the scope of the evidence from spotlight hospitals, and third, the scope of the issues in Module 3. In relation to process, we note CTI's helpful update on disclosure, for which we're grateful. I will briefly touch on, first, the need for position statements from state CPs, second, the length of the public hearings, and third, the need for restriction orders for vulnerable witnesses as appropriate. My lady, turning then first to substance and expert evidence. As your ladyship is aware, one of the systemic issues of particular concern to our clients is the impact of outsourcing on the NHS in the context of the pandemic. This is about the use of contract workers as well as NHS employees within NHS hospitals. For the avoidance of any doubt, it is not about the use of private hospitals. The inquiry has received our separate written representations that your ladyship and CPs would be assisted by the instruction of an expert in this area. There have been significant concerns raised from within the NHS about the impact of this outsourcing on the healthcare system and those working in it, in particular with regard to unfavourable contract terms, working conditions, and the overall impact on healthcare efficiency. Clearly, we submit, this is all highly pertinent to Module 3's scope. We submit that your ladyship in the inquiry would be greatly assisted by instructing such an expert and invite your ladyship's ruling in this regard. Second, spotlight hospitals. We submit that evidence from the spotlight hospitals should not be limited to senior managers. Evidence should also be obtained from frontline staff in both clinical and non-clinical roles, including those in outsourced positions and migrant workers with employment-dependent visas. They ought to be heard, given the crucially important role they played during the pandemic. Further, we have identified in our written submissions some particular points which we submit should be covered, and we have explained why we say that is the case. I need not repeat those submissions orally and refer your ladyship to them. Third, on substance, we support the submissions of Mind and FEMO and the John Campaign CP group on the need for access to adult mental health services to be included as a key area of examination in Module 3. The impact of the pandemic on mental health generally and the mental health of our clients' members in particular was extremely significant. Your ladyship and CTI have already reflected this at paragraph 7b of the provisional list of issues, for which we're grateful. Our clients' members carried the stress of an understaffed healthcare system and worked through their fear, uncertainty and exhaustion to provide essential services in the pandemic response. The trauma of working on the front line of a pandemic, unprotected both physically and contractually, cannot be understated. The consequent impact on the ability of the healthcare systems to respond to the pandemic as a result of health workers' declining mental health is paramount to the task at hand in this module. Examination of the impact of the pandemic on healthcare ought, we respectfully submit, to include an examination of the impact on access to adult mental health as well as treatment for physical health conditions. My lady, process. First, position statements from state CPs. We invite your ladyship to direct that the state CPs prepare and submit position statements in advance of the public hearings in order that CPs have sufficient notice of their respective positions and are able to prepare accordingly. Second, length of the public hearings. Like many other CPs, we are concerned that 10 weeks will not be enough for the public hearings given the breadth of this module, though we note what CTI has said in this regard. Third and finally, restriction orders for vulnerable witnesses. Many of our group's members are in precarious employment or have leave to remain directly tied to their employment. They are thereby exposed to potential repercussions should they provide impact evidence to your ladyship on systemic failures. They have important evidence to give to your ladyship. By way of example, one staff nurse worked on the COVID and non-COVID wards from the outset of the pandemic. She contracted COVID at work and had to be signed off after developing long COVID. She raised concerns about PPE early in the pandemic and was ignored and reprimanded by senior managers. She witnessed discriminatory treatment of Filipino and other BAME and migrant staff in the hospital. She has not received adequate support from her employer since being diagnosed with long COVID. By way of further example, we refer to 2 outsourced cleaners. During the pandemic, they raised concerns that they were being instructed to work on COVID wards without adequate training and without prior warning of contamination risk. There was also a notable lack of PPE, lateral flow tests, and access to vaccinations. They were given no time to wash or disinfect themselves before being sent to clean other non-COVID wards. They raised additional concerns that cleaners who contracted COVID-19 were not paid when self-isolating. This had led to outsourced cleaners who were unable to afford the unpaid sick leave, continuing to work whilst unwell. They did not have access to COVID-19 vaccinations, whereas the directly employed NHS hospital cleaners did. The vaccination programme appeared to function as a 2-tier system which treated employees as more important than outsourced staff, despite their shared risk of exposure. It was only through pursuing a grievance process with the hospital that IWGB was able to secure vaccinations for these workers. We request that your ladyship hears impact evidence from these vulnerable individuals, and we request that these vulnerable individuals are suitably protected from their further public service in giving such evidence to your ladyship's inquiry by restriction orders as appropriate. My lady, in conclusion, we're very grateful to your ladyship and to the inquiry team for all your considerable dedication to this module. We will continue to assist the inquiry in whatever ways we can. Those are the submissions of the Frontline Migrant Health Workers Group. My lady, unless I can be of any further assistance.
Thank you very much indeed for your help, Ms Sengupta. Very grateful. I saw the lectern arrive in good time. You're obviously very ready to go, Mr. Dugri. Thank you.
Thank you, my lady. I represent the Federation of Ethnic Minority Healthcare Organisations and will use the shorthand of FEMHO in my oral submissions. As you will be aware, FEMHO is a large consortium of Black, Asian and minority ethnic healthcare workers. Our members were on the front line and behind the scenes throughout the pandemic, working tirelessly under brutal pressures and conditions across the UK to support the public health services. A striking feature of the COVID-19 pandemic was the disproportionate impact on healthcare workers. Many of our members lost their own lives, colleagues, friends, family, and loved ones while suffering from the physical and mental burnout because of the conditions they were required to work in. Accordingly, my lady, FEMHO provides the inquiry with a unique and pivotal voice on the impact of the pandemic on healthcare systems and staff. Your ladyship would have received our written submissions, and I don't propose to repeat the same in my oral submissions. My submissions today will focus on 4 main topics. First, scope. Second, the Rule 9 requests and disclosure. Third, expert and impact witnesses. And fourthly, public hearings. Dealing firstly with scope. The inquiry had previously indicated that a revised list of issues would be provided in the spring of 2024. It is now being suggested that a second draft will be made ready for the end of May. Any further delay in the provision of the revised list of issues is likely to be counterproductive given the tight timeframes we are already under. It is also unnecessary. We say respectfully, there are obvious omissions from the provisional list of issues that ought to be immediately addressed. FEMHO stands firmly behind its submissions made at previous preliminary hearings that the examination of race inequality, both in terms of impact and root causes, should be explicit in the list of issues. We know your ladyship has demonstrated already in this inquiry a recognition of the importance of the issue of discrimination and inequality. It is therefore surprising to my clients that there has been no direct response from the inquiry to those submissions. The list of issues as presently drafted make no reference to specifically to the issue of race inequality. And this can be contrasted with specific references to inequalities in relation to other vulnerable groups, for example, those relating to age and disability. A comprehensive investigation into the impacts of Covid-19 on the healthcare system must include a thorough consideration of race inequality. It is important that this is officially acknowledged in the list of issues. In order to assist your inquiry, we submit the revised list of issues should include the following 5 issues. 1, whether, and if so, how, structural inequalities influence the capacity of the healthcare systems and workers. 2, socio-economic factors such as the impact of poverty, discrimination, and social exclusion. 3, specific challenges faced by ethnic minority healthcare workers, including inadequate access to PPE and occupational health support, and increased exposure to the virus due to high-risk clinical roles. 4, the impact of government policies and decisions, or lack of them, on black and minority ethnic people in the healthcare system. Engagement and consultation and inclusion with black, Asian, and minority ethnic communities and healthcare workers in the development of policies or interventions. We echo calls made by other core participants for greater clarity on the remit of healthcare within Module 3. We urge the inquiry not to narrow its focus purely on hospitals and instead take an expansive view that encompasses primary and community care services. Finally, in respect to scope, we support the submissions made by the long COVID groups. FEMHO's membership includes a cohort suffering from long COVID after occupational exposure, some of whom have had profoundly negative consequences and experiences in obtaining support and adjustment from their employers. We share the view that the scope of Module 3 should include an examination of how healthcare staff who develop long COVID as a result of their occupational exposure have or have not been supported. Second issue is Rule 19 requests and disclosure. FEMHO welcomes the Rule 9 requests to the Spotlight hospitals and notes what was said this morning. We have, though, 3 observations about the gathering of evidence on what was happening on the ground during the pandemic. First, a point that has been advanced by other core participants. We consider that the inquiry would benefit from carrying out a similar exercise in gathering information from a range of primary care services, and not just hospitals. We note CTI's observations that evidence already gathered means this isn't necessary. We would suggest a spotlight approach that we encourage you to adopt would ensure the inquiry hears from a range of people, including GP surgeries, mental health facilities, ambulance trusts, and other frontline community healthcare centres. Second, we are concerned that the Rule 9 requests have been sent to the Chief Medical Officers or equivalent roles, and we therefore echo the other submissions made by core participants in this regard. We do note Ms. Carey's submission this morning that requests specifically asks that the statement be provided by an appropriate person or individual. It is imperative that the Spotlight hospitals take an open and transparent approach to their responses, and defensive corporate statements from members of boards responsible for particular hospitals would undermine the integrity of this approach. The inquiry should ensure evidence is obtained from a full range of personnel in the hospital and primary care settings, including frontline workers. The responses should reflect the experiences of healthcare workers across the different levels and areas within the individual hospitals, and be candid in acknowledging any issues and negative experiences that were encountered. Third, whilst we are grateful to the inquiry in sharing the summary of topics that were covered in the Spotlight Hospital requests, we are concerned about the absence of specific references to evidence regarding the impact of treatment on vulnerable groups, and in particular Black and Asian and minority ethnic healthcare workers. In our submission, the Rule 9 requests ought to include topics specifically addressing racial inequalities, including but not limited to whether appropriate and effective risk assessments were carried out in the deployment of Black, Asian and minority ethnic healthcare workers, the extent of any diversity within the leadership, disproportionality in decisions regarding redeployment of staff into red zones or other high clerical risk areas, and finally, whether concerns regarding PPE access and suitability were raised and appropriately addressed. In relation to the wider disclosure process, whilst acknowledging the constraints caused by delays in material provider provision to the inquiry team, we remain concerned as to the progress with onward disclosure of material to the call participants. We have our full submissions set out at paragraphs 3.1 to 3.3 in our written submissions, and note what was said earlier. We simply stand behind those submissions and echo calls from other call participants on this point. Thirdly, my lady, expert and impact evidence. The inquiry's commitment to placing possible inequalities at the forefront of this investigation is of particular importance to FEMHO in this module, as this is where we say the impact of inequality cuts the sharpest. In line with that commitment, expert evidence on racial inequality on all aspects of healthcare and disproportionate outcomes should be obtained for Module 3. This should look at both patients and staff. We fully endorse and support the submissions made on behalf of the Bereaved Families for Justice group that there is a need for further healthcare-specific evidence in this regard. FEMHO implores the inquiry to go further than merely examining impact, but to investigate the root causes of the underlying inequalities within the healthcare system. We can achieve this by adopting what we say is a three-pronged approach. First, the inquiry should instruct its existing experts to produce addendum reports, and where necessary, instruct further experts to address the Module 3 specific matters in relation to discrimination and race inequality. We certainly do encourage the use of the existing expert evidence prepared for the purposes of other modules. However, it is inadequate in our submission to examine the Module 3 specific issues by merely adducing those reports. We respectfully do not agree with the Council to the inquiry's submission this morning that the background and context to those of those existing reports provides sufficient evidence in of itself to this module. They do not address the institutional or systemic issues within the healthcare setting, which it is imperative that this module investigates. Second, FEMHO urges the inquiry to prioritise calling a proportionate number of witnesses who are from diverse backgrounds, disciplines and locations across the UK, and who can speak to a range of systemic issues relevant to Module 3. FEMHO has many such witnesses who can provide this evidence. Our position is that the experience of FEMHO members speaks directly to the issues of health inequality as workers and users of the healthcare system. Their voice should not be limited to the Every Story Matters report. We are grateful for and encouraged by the requests for short summaries of impact evidence from a number of our members. We look forward to engaging with the inquiry and endeavour to assist in this regard. To assist this process, my lady, Saunders Law, those instructing me, have sent a letter to the inquiry team requesting that consideration is given to providing some protection to those individuals who are coming forward, such as anonymity. We are aligned with Ms. Gupta KC's submissions just now in this regard. As your ladyship will appreciate, many of our junior members and those in lower band and support roles have legitimate concerns about negative consequences and negative repercussions of speaking out. Third, we invite the inquiry to request evidence from the researchers on the UK REACH project, which is a study focused on the experiences of minority ethnic healthcare workers during the pandemic. We are grateful to Ms. Carey's confirmation that the inquiry are actively considering requests from call participants for further Rule 9 requests to be made to individuals or bodies. In our submission, it would greatly benefit Module 3 if witness evidence is obtained from UK REACH, as well as the study reports, which we are happy to provide the inquiry. We also urge the inquiry to revisit its consideration of adult mental health services within Module 3. Again, we welcome Ms. Carey's confirmation this morning that the mental health of healthcare workers is being examined. Individuals experiencing mental health problems died disproportionately during the pandemic, and the data indicates that Black, Asian and minority ethnic healthcare workers were overly represented within that cohort. Its impact on the healthcare system and its obvious impact on patients in accessing appropriate care should be examined. And we therefore endorse and support the submissions on behalf of Mind. Finally, my lady, in regards to public hearings, FEMHO shares the genuine concerns advanced on behalf of other core participants regarding the limited duration afforded to evidential hearings for Module 3. Given the breadth of the scope and the issues to be investigated, we are, of course, keen that progress is made expeditiously, but we respectfully invite the inquiry to allocate more days to Module 3 for it to be meaningful and effective. We also support submissions on behalf of the Bereaved Families for Justice group that a further preliminary hearing is likely to be necessary in preparation for the substantive hearings. And finally, we would also echo the concerns about timetabling and limited time windows before the public hearings are due to commence. We would urge the inquiry to adopt a pragmatic and sensible timetabling approach, namely prioritising early disclosure, particularly witness statements, allowing more time for EPs by starting this process earlier, aligning timetables with school holidays, and avoiding delays avoiding deadlines during and immediately after August. My lady, those are my submissions, unless there are any questions.
Very grateful to you. Thank you very much, Mr. Odogu. Right, who's next? Mr. Simblett. Oh, there you are.
Thank you, my lady. As my lady knows, we represent the Covid-19 Airborne Transmission Alliance, CATA, whom we've met in the previous two preliminary hearings. As we said on those occasions, CATA is here to help your inquiry to conduct an effective investigation, to obtain a proper evidential basis for meaningful and informed recommendations, and to encourage those to be expeditiously implemented before any future pandemic. Today, I wish to build on what I hope are regarded as our constructive written submissions and to emphasise that understanding how COVID-19 is and was transmitted is essential to any assessment of the appropriateness of the UK government response to the pandemic. That's particularly so in this module, where it's important to look at health and safety within the healthcare system during the pandemic, and appropriate to raise this at this last preliminary hearing, since such proper understanding of COVID transmission should inform fundamentally how you organise this module, including what it covers, managing disclosure, and the obtaining and selection of witnesses. So I shall address 3 points today. First, the implications of airborne transmissibility of the COVID virus in the healthcare system. Secondly, how that informs what should be considered to be healthcare in the context of this module. And thirdly, the IPC expertise that the inquiry should draw. So first, my lady, this being potentially our last opportunity to do so before the substantive Module 3 hearings, is why is the airborne transmissibility of COVID-19 important for an investigation of the healthcare system? Well, CATA submits that there were profound cascading consequences flowing from the initial response to the pandemic within the droplet paradigm and the very slow march to appreciating the virus's airborne nature. The impact on the healthcare system was grave. The failure to recognise the airborne nature of the COVID-19 virus, alongside the departure from existing policies, practices and procedures for dealing with unknown viruses, was disastrous. As CATA has explained previously in its written and oral submissions, there were procedures in place in the healthcare systems for dealing with airborne viruses. And it is a fundamental health and safety principle that airborne precautions should be followed until there is scientific evidence to the contrary. That's referred to as the precautionary principle. And this basic tenet underpinning health and safety legislation and practice should have informed the approaches to disease prevention and control within the healthcare system. In fact, what happened was exactly the opposite. As we've said in our written submissions at 2.6, alert messages were sent to healthcare workers stating that COVID-19 is not airborne in its transmission and is droplet carried. That was seriously misleading and wrong. As we have put it in our written submissions at paragraph 2.1, SARS-CoV-2 is unequivocally an airborne transmitted pathogen. That is to say, it is carried in tiny droplets known as aerosols. These are sufficiently small that they remain suspended in air for long periods of time and, when inhaled, initiate disease. So the UK government's pandemic response, treating SARS-CoV-2 as transmitted primarily by droplets as opposed to being an airborne virus, was seriously flawed and remained so. Any uncertainty around the means of transmission should have led on the precautionary principle to the presumption that the virus transmission was airborne and triggered the appropriate protections against this disease. And this serious misstep needs to be considered at all stages of your process. One direct impact upon CATA's membership of this failure was in terms of healthcare worker safety and the nature of such personal protective equipment as was provided. So, why were healthcare workers wearing only surgical masks? The appropriate kit to guard against airborne transmission is respiratory protective equipment such as powered respirators and FFP3 respirators. Or, as the BMA have highlighted in their written submissions, why was a stop order placed on FFP3 procurement in June 2020? This concerning revelation must be investigated thoroughly by the inquiry, given the profound impact it may have had on healthcare worker safety during the pandemic. And these issues are not just about healthcare worker safety, important though that obviously is. They affected the wider public with whom the healthcare workers were dealing, because the public were exposed to greater risks of infection and, of course, suffered an impact on the healthcare system through staff absences. Milady, the airborne nature of COVID also informs the second matter to be addressed. What should be investigated as healthcare systems in Module 3? CAT has always advocated for an expansive view of healthcare. Our written submissions express the concern that an overly restrictive definition of healthcare in Module 3 will result in a failure to investigate properly or at all healthcare administered within community settings. At the last preliminary hearing in September 2023, we were joined by other core participants who submitted that Modules 3 and 6 should run in tandem, since what is considered healthcare and social care cannot easily and sufficiently be demarcated. When looking at healthcare systems, the definition, we say, cannot depend on whether care is received in a hospital or not. We support on this point particularly the written submissions from John's campaign, and we say further, first, an airborne virus does not stop at the door of the hospital. Those working in healthcare systems very often do not only work in hospitals, and we've given many examples in our written submissions. And thirdly, there was conflicting advice, instructions, variations in equipment and practice provided either to the same categories of people in their different places, or particularly the same people working in different places who receive conflicting instruction according to where they actually are. So that, we say, cannot properly be examined unless you change what appears to be the approach. We say that the inquiry can only discharge its proper investigative duties if it interrogates also the impact of COVID-19 on community healthcare during the course of Module 3, and we seek confirmation that this matter will be considered appropriately within this module. So it's important for us to say this is not just simply a lament about hospitals or topics omitted from this module. Rather, our point is if you don't investigate the conflicting advice, instructions and policies and practices properly, you may end up with incorrect conclusions. You could proceed on a false premise, namely failing to understand how the interdependent nature of healthcare systems, and that word is important, systems, and the people in them were affected by COVID. You would proceed on a false assumption that the impact in hospitals can be examined as if a hospital is isolated from the rest of the healthcare system. And that is simply wrong and would almost inevitably lead to wrong answers. Thirdly, my lady, the inquiry's engagement with the appropriate infection prevention and control IPC guidance and appropriate expertise. We had provided various materials about that. We're pleased to be told today of the progress that there is being on that. Our submission is that health and safety law, such as the COSHH regulations and RPE standards, appear to have been ditched in favour of IPC guidance without legitimate or transparent justification. And we submit that the experts must address that issue. It's also, we say, important for the inquiry to obtain or to utilise such expert evidence on the correct approach to IPC guidance, not just looking back during COVID, but to provide clarity ahead of the next pandemic. Again, there were existing procedures in place which were not followed in relation to similar respiratory viruses. There was already substantial learning which could and should have been drawn upon at the outset of the pandemic in the formulation of the appropriate IPC guidance, and we support the Royal College of Nursing's call for a clear chronology of when, by whom, and how the IPC guidance was varied and then disseminated. The failure of IPC measures and the failure to recognise the fact of airborne transmission is thus key to understanding the significance of other issues that have been raised previously by CATA and other CPs in this inquiry. For instance, inadequate and unsuitable respiratory protective equipment, and why the failures in relation to those were so catastrophic, may well inform, for instance, the differential impact on those from a minority ethnic background, as highlighted by FEMHO and the frontline migrant workers, among others. More broadly, and as we and other CPs have submitted previously, the failure to look after healthcare workers not only caused and still causes the loss of their lives, health and financial security, it still has enduring consequences on healthcare provision now. On this, we agree with the submissions of the BMA at paragraphs 10 to 15 and welcome their support in paragraphs 20 to 22 of their submissions for the issues relating to the departure from usual health and safety reporting procedures and the RIDOR requirements about which we've made submissions previously. The expert evidence that you hear, my lady, is important not only for the understanding of past choices, but also to frame any recommendations for the future. Lack of access to such expertise was a significant factor that led to the vulnerability of healthcare to this airborne risk, and its lack of appreciation of the significance in airborne transmission was a significant failure. To conclude, my lady, after today there are only 151 days until the hearings begin. That sounds a lot of time. It's less than 6 months, and there is an immense amount to organise if this module is to investigate properly. CATA remains, of course, available to provide all possible assistance.
Thank you very much for your help, Mr. Simlett. Very grateful. Mr. Davis?
My name is Miss Davis. I am Head of Legal at Mind, the mental health charity. I'm assisted today by Mrs. Abdul, Vincent Nightingale and Miss Nee Moraine, part of the dedicated Mind legal team. And this gives me an opportunity to wish Eid Mubarak to my colleagues who are missing today. It's probably not well known that Mind was set up by the post-war Labour government, who set up our NHS and modern welfare state and social services. They had recognised in their vision for the country that a separate voice was needed for those with mental health problems, who were even more sorely discriminated against and stigmatised than they are today. Our mission was set then and remains today not to give up until those people with mental health problems are given the support and the respect that they need. And our mission is not set against the historic task of this inquiry, which is to learn the lessons that can be learnt from the pandemic for the prevention of future suffering. Counsel Ms Carey has said that the inquiry will look at key and significant issues. It's my job to persuade you that what happened to the nation's mental health during the pandemic and the impact on health services is both key and significant. We appreciate that the inquiry has to grapple with twin beasts, the scale of the information it has to review and the pace that must be adopted in order that recommendations will be practicable for future generations, or indeed this generation should another pandemic reach our shores. We see the argument that was put at the last preliminary hearing that we cannot examine every condition during this inquiry or look that was affected by the pandemic, and we cannot look in every nook and cranny. However, mental health problems are not every condition. They're a condition that everyone can get. In normal times, however we seek to define that now, 1 in 4 people will seek help for their mental health in any given year. During the pandemic, the scale of those mental health problems became gigantuan. Substantial parts of those mental health problems were, we say, predictable. We knew that SARS-1 carried post-viral depression syndrome, and it was reasonable to assume, until told otherwise, that SARS-2 would do the same. The impact of lockdown and shielding was bound to be detrimental for a significant portion of the population shut off from their social contact and their social support. We saw mass bereavements, often without the chance to say goodbye, and that created an obvious need. Our health service staff were under intolerable stress and were facing both death and COVID with inadequate PPE. The shutting of schools was bound to affect both parents and children alike, although perhaps the intensity of that was less predicted, according to the parents that I know. And yet there appeared not to be a public health, mental health plan to address what we say were these population health predictable issues. And why is that? I could give you a general opinion about the stigma and the status of those with mental health problems, but surely the answer is more nuanced than that. And I say a perfectly proper question for this inquiry to address. On top of those predictable problems, there were less expected issues. Many people with no prior
mental health problems experienced first and very serious episodes of psychosis, and found that their lives, actually particularly those who were, intubated in ICU for some reason. And those people found that their lives unravelled as a result of those illnesses. 8 million people sought and were turned away from mental health services because they were deemed not to be sick enough. Recent evidence showed that 1 in 9 children who are still carrying a mental health disability that started during the pandemic. Recently, figures were released that said that people in their 20s were off sick from work more than people in their 40s. The response from the government was not to learn some of the lessons that might have been to intervene in that issue, but the mental health culture had gone too far. We at Mind would say there's no such thing as mental health culture. There are only people and their families who are suffering.
Could we, I'm sorry to interrupt, Ms Davis, but we do have limited time. Could we go back to the issues I have to decide today in the preliminary hearing, please?
Yes, there was also perhaps less predictable were questions such as lack of PPE. That meant that there was rationing and prioritisation. Mental health inpatient and community services were not priorities for PPE, and that had an impact. This meant that during the first few weeks of lockdown, when a quarter of mental health inpatients were discharged early, community services, who were also not a priority, found themselves with what they say were both confusing guidance and inadequate or no PPE. This meant that the people who were meant to look after the discharged patients were simply not there or not knowing what to do. Psychiatric nurses are less trained in infection control, and that and the lack of PPE led to some really dreadful experiences for those that were left in hospitals. So, for example, we have had stories of people who lost all of their leave, even though they had previously many hours a day, and people who were locked in their rooms for up to 5 days at a time, then isolation, and who were denied access to basic things like showers. Could this have been handled better? Is there something we could do different? This, we say, are perfectly proper questions that this inquiry could answer. In terms of staff mental health, I know from my own experience at the Nightingale Hospital that they developed a programme of putting on your psychological PPE. Counsellors were available at all shifts. This wasn't rolled out across the NHS. I don't know why. And again, we say this is something the inquiry can look at. In terms of when mental health might be looked at, we were told that if not here, then maybe we would look in Module 6. There was nothing in Module 6 about mental health, and we say that Module 3 is the best place to look at these issues. Or the inquiry, I suppose, could have a separate module, but that's not for me to tell you what to do, it's just a suggestion. Or the inquiry could move some of the children's mental health into looking at children in schools, because the schools are such an integral part of the mental health referral system. And let me make clear, Baroness Hallett, I'm not disgruntled, I am hopeful. This is one of the most important events that we have taken part in. We want the COVID inquiry to succeed. We want its legacy to be that of a forward-looking inquiry that breaks with the tired tradition of excluding those of us with mental health problems because it's often easier to do so. Unless I can assist you further, that's the end of my submissions.
Thank you very much. Thank you for your help. I think we can take one more before we break, unless I'm told. Yep, Ms Morris.
Lady, our submissions are brief, and so that's probably a sound choice. I make submissions on behalf of the Royal College of Nursing. We maintain our written submissions, and therefore we don't repeat them now. We are encouraged by Counsel to the Inquiry's summary this morning.
Dance of the lecterns. Miss Morris, you should know about that by now.
I was just trying to be quick. So we are encouraged by Counsel to the Inquiry's summary of the evidence gleaned from the Spotlight hospitals. And the reason for that is that her summary of the content mirrors closely many of the key issues upon which the college itself focuses. We also welcome the indication as to the impact evidence which the inquiry will take, and in particular that it will be hearing from some nurses who were on the front line. Finally, we support the proposal made by Ms Hannett KC in relation to healthcare workers with long COVID, because many of our members are in the situation of having long COVID, and both because of its materiality for what happened at the time, but of course for its materiality for the healthcare system going forward. Staff shortages are a problem which is only intensified, and there also will be, we say, potential greater recruitment problems if healthcare workers perceive that they are not going to be protected or looked after if they sustain such an injury in the course of their work. That concludes my submissions, my lady.
Oh, they were brief. Thank you very much, Miss Morris. In which case, I'm going to go to, who's next? Ms Domingo.
Thank you, my lady. I think my submissions today will also be reasonably brief. My lady, I will make 3 sets of submissions this afternoon on behalf of 3 separate core participant organisations, the BMA, the National Pharmacy Association and the Royal Pharmaceutical Society. And the submissions will focus on the key issues and lines of inquiry that each of these organisations consider essential for exploration by the inquiry within Module 3. And these are the submissions on behalf of the British Medical Association. As the inquiry has heard in earlier modules, the pandemic had a tremendous impact on healthcare workers and their patients. The UK's health services entered the pandemic significantly understaffed and under-resourced, which severely affected the ability of these systems to weather the storm when COVID arrived. Healthcare staff worked tirelessly to safeguard the nation's health during the pandemic, often at great personal cost to their own physical and mental health. The impacts of the pandemic were not felt equally for patients or for staff, and many impacts continue to this day. Module 3 is a key opportunity for the inquiry to examine these experiences and ensure crucial lessons are learnt and improvements implemented. The BMA's submissions today are focused on the issue of safety of healthcare workers during the pandemic, and they highlight how a number of critical safety failures placed healthcare workers at unnecessary risk. These include the inadequate provision of appropriate PPE and RPE, coupled with inadequate infection prevention and control guidance, as well as failures to comply with health and safety requirements such as risk assessments and the reporting of occupational death and disease. The BMA has already detailed its very serious concerns about inadequate PPE, RPE and IPC guidance in Modules 1 and 2, and the impact this had on doctors and other healthcare workers on the front line. However, the BMA considers that Module 3 will be the opportunity to address these issues in more detail. Of particular concern is the recommendation within IPC guidance in favour of the use of fluid-resistant surgical masks, or FRSM, for the routine care of patients with confirmed or suspected COVID-19. FRSM masks are not PPE. They do not provide adequate protection against aerosol transmission, and this particular issue is symptomatic of a wider failure to properly recognise the risk of aerosol transmission and to recommend and implement appropriate measures in response. The evidence of Professor Catherine Noakes in Module 2 offered a number of explanations for the reluctance to fully acknowledge this risk, including the significant resource and operational implications for hospital infection control measures. This same issue is acknowledged within the technical report produced by the Chief Medical Officers and Chief Scientific Advisors, which is fully referenced within the BMA's written submissions, and identifies the management of PPE and best infection control advice as the issue that probably provided the greatest point of tension between medical practitioners and those trying to provide a standard approach to IPC. The BMA submits that this widespread acknowledgement within the profession of the significance of the issue requires thorough consideration by the inquiry, including the extent to which the safety of healthcare workers was compromised in favour of operational or cost considerations. Connected to inadequate PPE and IPC is a failure to comply with health and safety legislation. All employers are subject to a legal duty to undertake suitable and sufficient risk assessments, yet there was a widespread failure to do so within healthcare settings, with 69% of doctors responding to a BMA survey who contracted COVID-19 in 2020, telling the BMA that they had not been individually risk assessed before acquiring COVID. BMA surveys also identified that ethnic minority doctors more commonly went without PPE, felt worried or fearful about speaking out, and felt that risk assessments had been ineffective. Similarly, workplace protections are provided within the Reporting of Injuries, Diseases and Dangerous Occurrences Regulations 2013, or RIDOR, which require the reporting of a disease attributed to occupational exposure to a biological agent. However, despite healthcare workers being at significantly higher risk of COVID-19 infection because of the nature of their work, there was significant underreporting of cases of COVID-19 in healthcare settings throughout the pandemic. Reporting is crucial to understanding infections at health service staff level, how infection spreads within healthcare settings, and how to better protect staff and patients. This is critical information during a pandemic like COVID-19. However, there was considerable underreporting of disease and death under RIDOR. This underreporting has made it even more difficult for staff suffering from long COVID to access financial recompense. And the BMA asked the inquiry to consider the adequacy of the RIDOR guidance produced by the Health and Safety Executive and whether there is any evidence that reporting was discouraged. To conclude, while these submissions contain only brief selected examples of the ways in which the safety of healthcare workers were compromised, they evidence systemic failure which the BMA asked the inquiry to fully examine. Sadly, there are doctors and healthcare workers who lost their lives due to inadequate protection at work, and others who have suffered and continue to suffer significant physical and mental health impacts from working throughout the pandemic. This includes long COVID, the impact of which remains in far too many cases ongoing and potentially career-ending. These are extremely serious issues that require careful scrutiny by the inquiry so that meaningful and effective improvement can take place. And the BMA asks that they are examined in detail within the Module 3 hearings. My lady, shall I move on to...
Certainly, thank you.
I shall move on to the submissions on behalf of the National Pharmacy Association. These submissions highlight three principal issues that the NPA considers relevant to the scope of Module 3 and that ought to be examined within the Module 3 hearings later this year. The first issue is the central role that community pharmacy plays in local communities and in tackling health inequalities across the UK. Community pharmacies are part of primary care, and they have a unique understanding of the health needs of the populations and the communities they serve. They are disproportionately located in areas of higher deprivation, delivering health services to communities that need them most, and they play a crucial role in reducing health inequalities. A local pharmacy is one of the few places where patients can walk in off the street and access healthcare advice and treatment without an appointment. During the pandemic, community pharmacies played a core role in maintaining access to healthcare services. They became the first port of call for many patients, and MPA members experienced a huge increase in demand for healthcare advice and medicines, including an increase in the number of patients seeking advice for more serious health or mental health conditions. NPA members reported a significant increase in the number of prescriptions dispensed from February to March 2020, and phone calls to pharmacies more than tripled during this period. Home deliveries of medication to vulnerable patients more than doubled, and many pharmacies experienced long queues outside their doors. The role played by community pharmacy during the pandemic provided crucial support and resilience to the healthcare system. Pharmacists and their teams worked tirelessly to maintain service provision and ensure the supply of medicines to their local populations. Many medicines became difficult to source and expensive as demand outstripped supply, and staff spent long hours sourcing medicines. The increased demand on community pharmacy during the pandemic had a significant impact on pharmacists and their teams, resulting in stress, fatigue, and mental health issues for many MPA members. Given the essential nature of their frontline role, the inquiry is asked to consider whether there was sufficient investment by government in the infrastructure needed to integrate community pharmacy into the broader health system and to support effective cooperation across the health service. The second key issue is that community pharmacy was often overlooked and under-recognised. Despite the central role played by community pharmacy in the delivery of NHS care throughout the pandemic, community pharmacists and their teams were not given comparable treatment to other frontline healthcare workers, which meant that often they did not receive the support that they needed. The most significant and demoralising example of the different way in which community pharmacy was treated by government was the initial exclusion of pharmacy workers from the life assurance scheme for frontline workers in England. The MPA asked the inquiry to fully examine the circumstances that gave rise to this omission. Another example relates to PPE, which was not initially available to community pharmacy through the NHS, requiring many pharmacy teams to source and fund their own protective equipment. The supply of PPE was a challenge, and pharmacy teams put themselves at risk to help patients stay well, often working in close proximity to others and reusing PPE repeatedly for days or even weeks. The MPA suggests that the inquiry examines whether government properly and fairly considered the circumstances of all healthcare workers who contributed to the pandemic response. Thirdly, the inquiry is asked to consider the resilience of the independent community pharmacy sector in responding to a future pandemic. Community pharmacy entered the pandemic facing financial and workforce crises due to long-term underinvestment in the network. These issues presented significant challenges for community pharmacy in responding to the pandemic and increased the difficulties in providing services to patients and maintaining staffing levels. Even though the pandemic clearly showed that pharmacies are an essential part of health and social care, real-term funding cuts have continued, and the independent community pharmacy sector finds itself in a worse situation than at the outset of the pandemic, with pharmacies closing at the rate of approximately 8 per week. A strong community pharmacy network is an essential element of healthcare services in the UK, and the MPA invites the inquiry to consider the role of community pharmacy in pandemic planning and in the overall resilience of the UK's healthcare system to respond to a future pandemic. I have one final set of submissions. Shall I proceed?
Yes, please.
My lady, the third and final set of submissions are made on behalf of the Royal Pharmaceutical Society. They highlight 5 key areas that the RPS submits should be examined by the inquiry in Module 3. First, safety at work for pharmacists. Failures to ensure the safety of healthcare workers and pharmacy teams, including through appropriate use of risk assessments and the provision of suitable PPE, must be considered. The inquiry is specifically asked to examine whether rules on testing, contact tracing, and self-isolation, including infection prevention and control guidance, were appropriate for all healthcare settings, including pharmacies. For example, social distancing in pharmacy settings was often impractical, and the RPS received reports of inconsistent approaches to self-isolation rules around the country, which potentially meant that some pharmacies had to close or were no longer able to support patient care. Second, the role played by pharmacists working within hospital settings. The work of pharmacists within hospitals is sometimes overlooked. During the pandemic, hospital pharmacists cared for the most critically ill patients with Covid-19, transforming services to support colleagues and ensuring the supply of medicines for critical care. Pharmacists also played a key role in rapidly establishing field hospitals, and the RPS admits that these contributions should be examined in Module 3. Third, a significant concern which is shared with the MPA, the repeated and systemic difference in treatments between pharmacists who provided NHS contracted services compared with healthcare workers directly employed by the NHS. The disparity in treatment can be seen in the exclusion of pharmacists from visa extensions provided to other healthcare workers in March 2020, in the absence of specific mention of pharmacists and their teams in guidance regarding key workers, which impacted childcare provision at school hubs, and perhaps most egregiously, in the omission of pharmacists from the life assurance scheme for the families of frontline health and care workers in England in April 2020. Despite their crucial role providing care throughout the pandemic, the pharmacy profession, and particularly community pharmacy, was often an afterthought in government planning, guidance and communications, and this had a hugely detrimental impact on their morale and well-being. Fourth, the resilience of pharmacy services in the event of a future pandemic or health emergency. During the COVID pandemic, community pharmacies were easily accessible and provided vital medication, health advice, testing and vaccinations. They played a pivotal role in protecting the health of their communities. However, community pharmacy is under very significant pressure, which is leading to the closure of pharmacies in local communities. There is also significant concern around the health and well-being of pharmacists and their staff and workforce capacity. The pandemic placed enormous strain on staff, and RPS workforce surveys demonstrate that pharmacists are suffering from burnout and long COVID. At the start of the pandemic, access to wellbeing services was not universal across the UK, and the RPS admits that all pharmacists should have equal access to wellbeing support, including for long COVID, regardless of where they work. The pandemic exposed the international complexity of the medicine supply chain, leading to shortages of many commonly used medicines such as paracetamol, as well as medicines used in critical care. In the years since, it has become increasingly common to see medicines shortages within fragile supply chains, and the RPS has recently launched a new research project to examine this issue in more detail. The inquiry is asked to consider the resilience of medication supply and pharmacy services across all care settings in the event of a future pandemic. Specifically, the current investment and planning in the medicines supply chain, in medicines production facilities, including aseptic pharmacy facilities and hospitals, and in the role of frontline and volunteer workforce in preparation for future pandemics. The fifth point is on lessons learned. The RPS admits that lessons learned must include longer-term reforms to better manage demand and build resilience across the health service. The pandemic highlighted the need for professional empowerment and regulatory flexibilities to allow all health professionals to put patients first. This included steps to help pharmacists better manage the impact of medicine shortages on patient care, such as enabling the reuse of unused medicines in care homes and hospices. The RPS also wishes to emphasise the importance of early engagement by government and NHS leadership with pharmacy stakeholders. For example, around medicines delivery services and supporting the planning and rollout of a mass vaccination programme, and the need for pharmacists in all care settings to have read and write access to patient records to support patient care. The RPS encourages the inquiry to seek to identify lessons such as these so that they can be embedded within working practices going forward to ensure that we are better prepared in the future. Finally, and in relation to experts, it was mentioned earlier this morning by counsel to the inquiry that the RPS seeks the appointment of an expert in pharmacy, and I wish to clarify that the RPS is not proposing an additional expert witness. rather that the instructed experts, for example in critical care, primary care and IPC, take account of the role played by pharmacists and the impact on pharmacists and pharmacy settings. Thank you, my lady.
Thank you very much, Mr. Mingo. Anything by way of response, Ms. Carroll?
Nothing from me, my lady.
Well, thank you all very much indeed. I confess that when I was reminded there were 36 call participants, 15 of whom wanted to make oral submissions, I was a little concerned. But may I congratulate everybody on the focus of their submissions and the timeliness of them. I shall consider, I would say consider them all, but I'm going to have to say this in a moment. And I will, having considered them, issue a ruling. And I'm not going to say consider them all because there's one decision that I'm afraid I cannot revisit and I shall not revisit, and I think it's only fair to everybody that I make that plain this afternoon. And that is the decision as to the timetable of this module. For reasons I'll explain in a moment, this module, Module 3, will start in early September, as Ms Carey explained. It will last for 10 weeks with a 2-week break in the middle to ensure that everybody is effectively prepared for the second half of the hearings. Let me just give one or two of the reasons that have led me to that decision. As anybody who's ever read my terms of reference, they'll know they are extraordinarily broad. They are the broadest terms of reference any statutory inquiry has ever faced, and we have a huge amount of work to get through. And because I've set a tight timetable and because I want to get recommendations implemented as soon as possible, that means that I have to get through the work as soon as possible. And that means that the longer I allow for any one module, the more issues I add to the scope of any one module, then the more delay to other modules. So for the moment, 2025 has a whole sequence of modules that hope to have their hearings in 2025, including care and children and young people. And I have to say that if I made Module 3 go longer, then I'd ask people what would they say to the core participants and those interested in care and in children and young people. I also have to say that if I do decide to add to the issues of Module 3, something will have to give. In other words, there isn't unlimited time. So although I fully understand why people have made the submissions that they have, and I fully understand the concerns, I'm afraid we have to live with the time and the resources that we have. I also wish people to understand, and not everyone seems to understand this, that because an issue is not included in a specific module does not mean the inquiry will not be considering it at all. As many people will understand, there are a number of ways in which we can gather evidence. Oral hearings is part of it, but also I can commission research, I can commission expert evidence. There are a number of different ways in which I can gather material. Oral hearings are just one part. They are an important part because they hold people to account in public, but they are only one part of the inquiry process. And I will not reach any conclusions until I have analysed and been assisted in analysis of all the relevant written material before me. So please do not think that because you do not see the express words X, Y, Z, that means in a specific module, that means that X, Y, Z will not be considered. I am exploring all the different ways at the moment with the team, and as soon as I'm able to do, I will make my plans for the future public. And I'm sorry that it takes time, but as I'm sure, again, those with inquiry experience will understand, we learn a lot as we go along, and there's been a huge amount on the plate of the inquiry team, but I will make it public as soon as I can because I know people want to know what's going to happen so they can prepare themselves accordingly. So I will make everything public when I can. I will make the ruling public when I can. And if people want to see the rulings or the written evidence to which I've just referred, they can always access the website. So thank you all very much indeed. I think the next public hearing is in Belfast, at the end of April. So thank you all for your help and for the constructive nature of the submissions, and that's all for this afternoon.
Thank you, my lady.